Today marks the end of an intense August in court at the City Harvest trial. Kong Hee has been on the stand for the past 3 weeks and is still undergoing cross-examination by the prosecution. One of the many questions Kong was asked this week was this: would CHC have sued Extron if Extron could not ultimately make good on its bond repayments? If Extron was not able to fulfill its legal obligation, then the church would have to sue Extron. Kong told the court in reply to DPP Christopher Ong's question if CHC was prepared to sue Extron to recover the monies if the events company had been unable to repay the bond investments. This would have been the logical course of action had this hypothetical situation come to pass. CHC and Extron were separate entities, and CHC as the bond buyer would have been put in a position to legally sue for losses. Emails presented in court suggested that the terms of the Extron bond agreement, its amount, interest rate and maturity period were determined by the defendants without consultation with the Extron directors. Evidence also suggested that the Extron directors did not control the drawdown of the bonds each time payment was requested by US music producer Justin Hurts. Kong disagreed, stating that the bonds could not be a sham transaction because Extron had every intention to fulfill its legal obligation to CHC. Kong told to the court that co-defendant Serena Wee had met up with both Extron directors Chung Ka-wing and Wayu Hanafi in early May 2007 to obtain their approval of Extron's budget and San Ho's US album sales projections, which showed strong prospects of recoverability by December 2008. This was before the Extron bond agreement was signed. Kong and his team were then subsequently authorized by the Extron directors to make drawdowns for individual expenses. The prosecution pointed out that although none of the defendants sat on Extron's board, evidence showed them discussing how Extron could meet its loan obligations and bond repayments. These plans included the church paying Extron increased retainer fees and rentals. It appeared this was to ensure that Extron's cash flow problems were answered. Kong explained that the monies were for real, legitimate and commercially viable services provided by Extron. In addition, the defendants were partners working with Extron's management on the crossover project. Ultimately, the CHC board had to authorize the payments and Extron directors had to agree to the proposals. DPP Ong questioned the decision to change San Ho's management company from Extron to Ultimate Assets and submitted that the only real reason for that was because of the defendants' concern about the disclosure required. Over the past 2 weeks in court, the court has heard Kong's evidence that he preferred to disclose only what he was legally obliged to disclose, bound by legality and the advice of professionals. Kong told the court that in 2008, auditor Fung Dao Cheng had also advised that there was disclosure obligation as Ho was now regarded as a key player in the company. Extron had already started to help CHC with the property search for a new building. The concern was not for disclosure per se, but rather what the disclosure would do to the property search and the crossover project, Kong explained. Hanafi was approached and he agreed to independently support the crossover project out of Ultimate Assets. A profit-sharing plan was subsequently set up between Extron and Ultimate Assets to ensure Extron was still reimbursed when there are album profits. The DPP pointed out that Hanafi's personal guarantee was only signed in 2010 and questioned the existence of the verbal agreement he had given to Kong, saying that he wanted to support the crossover project in 2002. DPP Ong submitted that it was a sham and the defendants did not rely on it when they entered into the Extron bonds. He also put to Kong that there was never any intention for Extron to repay the bond subscriptions. Kong disagreed, pointing out the fact that the budget spreadsheets for the US crossover showed that there was a clear plan for the US album to recoup its cost, which would allow Extron to repay the bonds. The DPP asked Kong if he relied on Hanafi's personal guarantee despite knowing that he had cash flow issues between 2006 and 2007. Kong explained that while Hanafi was asset-rich but cash-poor, it would not have been an issue for Hanafi to make good his personal guarantee. The DPP charged that Kong had given no consideration to Extron's liability concerning the bonds. From evidence, Kong was seen to be telling the American music team separately to be bold with your budgeting, to spare no expense, and that the sky is the limit. To this charge, Kong told the court that when it came to budgeting, he would lay out the outer parameters of maximum expenses projected for the Extron directors. On the other hand, he had also done extensive budget planning exercises with actual spreadsheets shown in court over the course of the trial. In discussions shown, Kong asserted that he had challenged the figures given by the Americans and pushed for expenses to be reasonable. The DPP sought to show that Kong was not aware of the 2-year maturity date of the first Extron bonds subscription. Email evidence showed that after the $13 million bonds had been drawn down, it would take 6 years instead of 2 to recoup the $12.45 million. Ong questioned how Kong planned to redeem the bonds within 2 years. Kong replied that based on 2007 budget with projected sales of 1.5 million copies of the album, the bonds would have been paid in full within 2 years. However, the album launch was delayed, and Chewing Han subsequently proposed a solution to extend the bond maturity date. In the 2008 budget put up by Hertz, it was shown in 5 years, the net profit of the music album would have yielded US $32.9 million, more than sufficient to cover the bonds with interest. The City Harvest trial resumes on September 8. For more information, log on to citynews.sg. I'm Sandy Yeoh, City News, Singapore.